They say you're innocent until proven guilty. But have you ever seen someone get arrested, thrown in jail, and treated like a criminal even before they stepped foot into a courtroom? Let me show you how this phrase is supposed to work and how it actually works in the system. But first, where did innocent until proven guilty actually come from? So the idea of presuming innocence isn't actually new. It dates way back to Roman law, where a jurist, his name is Julius Paulus Prudentissimus, 3rd century AD, he wrote, "The burden of proof is on the one who asserts, not on the one who denies." Now, this concept carried into English law. Now, the courts held there that it is better for 10 guilty people to go free than for one innocent person to be wrongly convicted. So the United States adopted this principle of innocent until proven guilty from English common law and then reinforced it in the 5th, 6th, and 14th Amendments. The 5th Amendment, the protection against self-incrimination and double jeopardy. In the 6th Amendment, the right to a fair trial, legal counsel, and an impartial jury. And then in the 14th Amendment, which ensures due process and equal protection under the law. Let's hop into this key U.S. Supreme Court case, Coffin v. United States. 1895 is when it was decided the U.S. Supreme Court officially recognized the presumption of innocence as a fundamental principle. The court ruled that jurors must be instructed that the defendant is presumed innocent until the prosecution proves guilt beyond a reasonable doubt. What does this concept actually mean? So innocent until proven guilty isn't a phrase. It's a rule. It just means that the government, the people charging anyone with the crime, right? They must prove beyond a reasonable doubt that they did it. And that person being charged, they don't have to prove anything. Now, you may be asking yourself, why? Well, it's because the burden of proof is always on the prosecution and not the defendant. If there's any reasonable doubt, the jury must find the person not guilty. Now, let's pretend we're in trial. I'm going to teach you, like you're a jury, about burdens of proof. All right, awesome. So thank you for popping and being on our jury. And so I just really want to make sure that you all understand what burdens of proof mean. And so we talked about what innocent until proven guilty means, but for us to really understand how that is going to factor into this case, you got to know what all these burdens mean. And so the lowest burden is called reasonable suspicion. Now, what is reasonable suspicion? Like, you're really going to see this a lot at the very lowest level. That is just what a cop has, where he's able to see some sort of specific and he has to be able to articulate something that is giving him reasonable suspicion. Usually in traffic stops, stop and frisk, you'll see that. That's the very lowest level. Now, that's not enough to arrest you. The one above it, probable cause, that one, it just means that it's more probable than not that you did something, right? And a lot of times we're going to see this when you're being arrested, because that's all it takes for you to be arrested. And when I'm speaking to the juries, I really like you all to understand that for you to get to this level of where a criminal trial is, right, where we're having a criminal trial, beyond a reasonable doubt, this is the burden here, but that's not been the burden the entire time. To get you here, right? And we know that 97% of people take pleas. So a lot of people never even get to the point where they're utilizing beyond a reasonable doubt, right? So at probable cause, that's enough to arrest you, and that's enough to send your case to the grand jury. That's enough for the grand jury to then decide and indict you and send you to criminal court. And then when you finally get to criminal court, you then decide to have a trial and you get in front of a jury, or you can do a bench trial in front of a judge. And then now you have beyond a reasonable doubt. But we had to go through a whole lot to get you there, right? And a lot of people don't weather that storm well. And so fizzle out before we get there. They take pleas and they never ever get to utilize beyond a reasonable doubt. Then we have preponderance of the evidence, and preponderance of the evidence is the next level up. That is in civil cases you'll see a lot, and you're not going to see that well in criminal courts. You'll see it in some situations, but for our purposes you don't see it a whole hell of a lot. Clear and convincing evidence is what needs to be utilized when someone is trying to take your children away, right? They have to prove it by clear and convincing evidence, and then boom, it brings it all the way up to beyond a reasonable doubt. And now that is the highest law in the land. That is actually the one that we get to when we're having a criminal trial, right? So The state must prove every element of a person's case who has been charged, right? And so when we know that, then we actually have to look and see, okay, what is this person charged with? And let's just say that this person is charged with with possession with intent to resell marijuana, right? And then they have to prove that, okay, one, that this person actually knowingly possessed this controlled substance, and then two, they have to then prove that and they got to prove that beyond a reasonable doubt. Then they have to also prove beyond a reasonable doubt that this person possessed it with the intent to distribute it to another person. So now you're able to see how many times people are just overcharged, right? And it's a tactic, and it's usually a tactic used by the government, so that way they're able to force you into a plea, and now it makes even more sense how 97% of people end up taking pleas, right? But as you're following along and you're listening to all the evidence, I just need you to know that every step of the way, if you feel like, it's highly unlikely that they did this, okay, well, that's not guilty. If you feel like, well, they probably did, probably not, well, that's not guilty. If you feel like, well, may not be guilty, well, that's still a not guilty. If you feel like, well, perhaps, that is still a not guilty. Well, if you're even at a suspected, right? Well, there's some suspected guilt. That's not guilty. Possibly, probably, that's not enough. Is guilt likely or even highly likely? It's still not enough for not guilty. Beyond a reasonable doubt. Guilt beyond a reasonable doubt is what is the law of the land. And why is this the case? Well, it's because, again, remember where innocent until proven guilty came from. Remember that thought process is better than 10 guilty people to go free than one innocent person to be wrongly convicted. And you can be wrongly convicted of a charge. Just because you're overcharged with it doesn't mean that is what you're guilty of, right? Doesn't mean that's what you actually did, right? And it's on the state to actually be able to articulate that and utilize evidence to overcome this very high burden. And guess what? The person charged, they do not have to help. And why? It's because they're innocent until they're proven guilty. So hopefully now you understand why it is so important to adopt an innocent until proven guilty mindset from the start, right? We discussed it. Every step in the case, every step in a criminal case, anytime someone comes into this system, it is due to a very low threshold, right? And who determines whether or not that threshold has been met? Obviously, cops, police, right? Government officials, they determine this. And oftentimes they complain about not having a lot of resources and maybe not having a lot of training. I know a lot of times when we're in court, we're hearing that. We're under resourced. We don't have all of this. So no, I didn't get that training. No, I didn't understand this. No, I don't really know that. So they're out here just kind of doing whatever they feel is best, right? It's just enough. Oh, well, it's enough. Oh, you probably did it. Let me get you wrapped up into this system. And guess what? 97% of those people are going to take pleas. And their decisions are often wrapped up in whatever preconceived notions or biases they may already have about the people that they come into contact with. And so now we understand why in America, innocent until proven guilty honestly just depends on who you are. Because the reality is, for Black and brown people, the moment that you're accused, you're treated as if you're guilty. Come on now, we've seen this in the news, in the media many times, right? Well, if there is a white suspect, they may get called trouble, while a Black suspect is definitely going to get labeled a criminal. And then Black and brown defendants are more likely to be denied bail, meaning they sit in jail for months or years before trial, even if they're innocent. Come here, Kalief Browder. Then we also know that Black people make up 13% of the U.S. population, but 47% of the known wrongful convictions. So key takeaways here. We know that innocent until proven guilty is the law, but it's not reality for everyone. We also know that burden of proof means that the prosecution must prove guilt, and defendants, people who are being accused, don't have to prove innocence. We also have learned that beyond a reasonable doubt means if there's any real doubt, the jury must find not guilty. But we truly learned that this standard definitely isn't applied equally. Most people don't even know that different legal standards apply at different stages of a case. And that's why this system is built to trap people who don't understand their rights. Criminal justice literacy in general. But luckily, you are here and you will. Our discussion prompt for today is going to be, have you or someone you know been treated as guilty before a trial? Drop your story in the comments and let's have a discussion around this. Don't forget, you get class participation for discussions.